Hi, I'm Michael Quinn, one of the directors of the Quinn Group. Today's topic relates to wills, powers of attorney and enduring guardian documents. These are very difficult issues to discuss with others, so we'll go through each of these documents one by one. A will is one of the most important documents that you will sign in your lifetime. It's basically a document that states how you wish your estate to be divided upon your death. Now, there are a number of things that you need to be aware of when making a will, because it needs to be done a certain way. So, what's the important parts of a will? Well, first of all, you need to have an executor or executors. In the past, family and friends were appointed as executor or executors. These days, more accountants and solicitors are being appointed as executors because they have insurance to cover any issues relating to the improper distribution of any of the assets of the estate. Whereas if you have an individual that undertakes the job of executor, they may be personally sued if there is any evidence of maladministration of the estate. You also need to think about specific gifts. For example, you can give cash or property or shares or artwork or collectibles or memorabilia or jewellery to specific family members or friends. They need to be nominated in the will. You need to have consider who in fact are your beneficiaries, the people that actually benefit from your will, whether they be family members or friends. If you have children that are under the age of 18, you should nominate a guardian for those children, just in case you and your partner pass in a car accident, for example. Now, both the executor and the guardian must be physically asked by you to undertake these important roles, and they should agree, obviously, to attend to these roles. So they should be asked prior to you actually completing the will. In many instances where you're distributing to a beneficiary who is under the age of 18, you would hold property in trust for them to a certain age. 18, 21, 25 or 29 are the most commonly used ages. And the trustee, the executor, the trustee, has power to hold those assets in trust for the maintenance, advancement and education of that particular beneficiary. Once the relevant age is met, then a lump sum is paid out to that beneficiary. You also need to think about whether you're going to be buried or cremated, and whether you want any special or have any special wishes in relation to burial or cremation. In other words, your ashes to be scattered at sea or scattered in a particular place, for example. The second important document that you need to consider is a power of attorney. A power of attorney actually is a document that can be brought into play whilst you're alive, as opposed to a will which comes into play once you die. It's a binding legal document that authorises an attorney to make financial, legal and property decisions on your behalf. For example, operating your bank account or selling property for you. There are two types of power of attorney that you can make. You can make what's called an ordinary power of attorney, which terminates once you die and will also expire if you lose mental capacity, and an enduring power of attorney. An enduring power of attorney is the most common power of attorney. It remains in force even if you lose mental capacity. Both ordinary and enduring powers will terminate if you die become bankrupt or insolvent. You can have your attorney can either be one or more persons and can operate either jointly together or severally individually. So you need to think about that appointment. So the main advantage of a power of attorney is that it allows your attorney, should you lose your mental capacity, to attend to payment of your bills and manage your estate whilst you are in that situation. The third important document is an enduring guardianship document. Unlike a power of attorney, an enduring guardian has the power to make personal, medical and lifestyle decisions on your behalf. Once again, whilst you're alive, it can operate. Personal matters generally include education, employment and healthcare. Your enduring guardian must consider your wishes, but ultimately they should make decisions in your best interests should you become mentally incapacitated due to an accident or illness, such as dementia or Alzheimer's. It is possible that an appointed attorney or guardian might act outside the scope of their authority, so it's important to choose someone you trust to ensure that this does not happen. So there it is. You owe it to yourself and your family to have a will, power of attorney and enduring guardian document in place. These documents should also be reviewed every 5 years on average. They are also very important documents from an estate planning point of view. If you need any assistance with any of the documents, please phone us or you can email us at info@quinns.com.au. That's all for now. We would love to get your feedback, so please like, comment or subscribe to this channel, Quintessential TV. Join us next time. I'm Michael Quinn. Bye for now.